us have Caso Estudio. Let us study one of the pen cases of Justice Mario V Lopez. This is the Commissioner of Internal Revenue versus PHILEX Mining Corporation, GR number 230016, November 23, 2020. This is in the field of taxation. So, on March 31, 2015, the CTA Division partly granted the PHILEX Mining's petitions. Si PHILEX Mining petition kasi filed its administrative and judicial claim for refund within the period prescribed under sections 112 of paragraph A and C of the 1997 National Internal Revenue Code, the NIRC, as amended. And that it attached to the claimant information sheets the required documents to support its claims. Okay, sabi ng CTA Division, kompleto. Now, sabi naman nag-appeal si CIR, si Commissioner of Internal Revenues, appealed the decision of CTA Division to the Supreme Court, claiming PHILEX Mining did not comply with the requirements of Section 4.113-3 of the Revenue Regulations number 16/2005 to keep, preserve, and maintain subsidiary sales and purchase journals. Hindi daw na-comply yan. Likewise, PHILEX Mining failed to prove that it filed the monthly VAT declarations required Section 114A of the Tax Code implemented by Section 4.114-1 of the Revenue Regulation number 16/2005. Hindi daw na-comply din. So now, sabi ng CIR, the CIR opines that prior compliance with these requirements is a condition sine qua non in claiming unutilized zero-rated input VAT because the subsidiary journals and monthly VAT declarations will assist the CIR and the courts in determining whether PHILEX Mining incurred input taxes in connection with its zero-rated sales and whether the input taxes were not applied against any output tax liability. So, these are the allegations of the Commissioner on Internal Revenue nang sabi ng CIR na hindi daw na-comply yung subsidiary journals pati yung monthly VAT declarations. Because complying this is a sine qua non condition. Ano ibig sabihin ng condition sine qua non? It's a prerequisite. So the issue now in this case is whether or not the CIR is correct in assailing PHILEX Mining's refund. Correct ba yung sinasabi ng CIR dun sa petition ng PHILEX Mining sa gusto nilang refund? According to the Supreme Court, no, CIR is not correct. It's not correct in assailing PHILEX Mining's refund. Bakit? The language used in Section 10, Section 110 is plain, clear, and unambiguous. To be creditable, the input taxes must be evidenced by validly issued invoices and or official receipts containing the information enumerated in sections 113 and 237. So, yan lang. The law says under section 110, para to be creditable with the input taxes, valid sales invoice lang, valid issued invoices pati mga OR. The law does not require that subsidiary journals where the sales and purchases and the output taxes and their corresponding input taxes were recorded are also kept. The law does not require, hindi na daw kailangan ng, sabi ng batas, hindi na kailangan ng subsidiary journals. Ang kailangan lang is yung mga issued invoices, pati official receipts containing the information under sections 113 and 237. Na-comply naman ni PHILEX Mining yan. And also, sabi ng batas, it is not necessary to have subsidiary journals. Ano ba meron dyan sa subsidiary journals? Ito yung mga nakalagay doon, naka-indicate yung mga input taxes and their corresponding input taxes. Indeed, courts may not in the guise of interpretation, enlarge the scope of a statute, and include therein situations not provided nor intended by the lawmakers. So, in there in this interpretation, the court must not expand the coverage of this law, the coverage of the statute. Only what is intended only by the lawmakers. To do so would be to do violence to the language of the law and to invade the legislative sphere. Kasi in this case, si CIR, ini-interpret niya na kailangan pa daw yung mga subsidiary journals na in which the section 10, section 1110 is clear and unambiguous na hindi na kailangan. Ang kailangan lang para maging creditable, para makaklaim sila ng refund is only the issued invoices and OR. In all, PHILEX Mining's failure to maintain subsidiary sales and purchase journals or to file the monthly VAT declarations should not result in the outright denial of its claim for refund or credit of unutilized input VAT attributable to its zero-rated sales. So, the failure to maintain that, yung na-fail, di ba? PHILEX Mining's failed to maintain these subsidiary sales and purchase journals. They failed on that. But it does not necessarily na denial yung claim nila for refund. Outright denial should not result in the outright denial. The failure to maintain that subsidiary sales and purchase journals should not be an outright denial of its claim for refund. Hindi yun ground. It's not a ground for outright denial of their claim for refund or credit of unutilized input VAT at creditable credit of unutilized input VAT. These are not part of the requirements for PHILEX Mining to be entitled thereto. Section 112A of the tax code is clear. No construction or interpretation is needed. Wala. Very clear ang section 112. The court may not construe a statute that is free from doubt. Kapag wala namang doubt, then why will construe or interpret? Neither can we impose conditions or limitations when none is provided for.